Okay, so I think we are ready to start. Good morning, good afternoon, good evening for everyone. I'm Esther Kismödi, Chief Executive of SRHM, Sexual and Reproductive Health Matters. That is an organization promoting sexual and reproductive health and rights globally. Our work is organized around the peer-reviewed open access journal, the SRHM journal, and we are actively linking our knowledge to capacity building, law, policy, and program development and advocacy. Welcome for everyone joining this webinar that will take 1 hour. We can connect you through the chat, and Jessica, our communication manager, will give you some more information. The chat is only available for the panelists. We see what you write, but you may not get from us the responses. And we cannot see you. You can see us, but it would be too many screens to share on the main screen if you would let everybody to join. So if you have any technical issues, please use the chat for that. I'm welcoming our panelists, Joanna Erdman, the McBain Chair in Health, Law and Policy in the Schulich School of Law, Dalhousie University, Canada. Verónica Undurraga, who is joining us from Chile, who is an associate professor at the Adolfo Ibáñez University. And Veloshnee Govender, who is a health economist, health policy and system researcher at HRP Department of Reproductive Health and Research in Geneva in WHO. So welcome for everyone. And before we are going into the content of this webinar, I would give the floor to Jessica, who would give the participants, the webinar participants, a couple of technical information. Jessica.
Thank you, Esther, and welcome to everybody that has joined us today. As Esther mentioned, at the bottom of your screen, you can select the chat function. That's where we will be collecting your questions to address at the end of the webinar. We will not be using the raise hand function, so I think just focus any questions you have straight to the chat. And if you would like to join us on Twitter, we are using the hashtag abortionishealthcare, and you can tag us at SRHM Journal.
Thank you very much, Jessica. So we are organizing this webinar to discuss some very important issues around criminal abortion laws and especially the gender justice perspectives of it. And we are using and welcoming two most recently published papers by Verónica and Joanna in SRHM. And we are linking it to our recent ongoing call for papers on rights perspective of universal health coverage and sexual and reproductive health. And we have invited Veloshnee to connect the criminal legal perspective and gender justice perspectives to the public health relevance. We are hoping that this webinar is a first of a webinar series. And we are hoping that the next webinar, we will engage on the same topics with some public health experts from different countries and see how it resonates, the topic from a country perspective. So I'm moving to Joanna. And I would like to ask you, Joanna, that your most recently published paper in SRHM discusses the treatment of criminal abortion laws as a form of sex discrimination under international human rights law, and provides us insights about the nature and content of structural discrimination that characterizes such abortion laws. Can you please tell us more about your analysis and the considerations and relevance of gender injustice perspectives of these laws?
Great, thank you. I'll share just a PowerPoint here, bring it up on the screen. Can you all see it?
Yes.
Great. All right, so thanks so much, Esther. This article is about two cases, Mellett and Whelan, And these are cases where the United Nations Human Rights Committee declared the Irish abortion law, which was then in effect, to be a violation of human rights. But the case is interesting because the committee did so on the basis of sex discrimination. And the controversy of the case, but some, including me, think the brilliance of the case, is that it rooted the sex discrimination in an inequality of treatment between women rather than between women and men. So specifically, it focused on the way in which the law treated differently women like Mellett and Whelan, who chose to terminate their non-viable pregnancies, as compared to women who chose to continue those pregnancies. Now, for some, running this analysis on the basis of a comparison between women was considered a desperate move on the part of the committee. You know, it was seen as a kind of concession to those who say you just can't run sex equality claims on issues like abortion because there is no male comparator. So desperate to run this equality claim, the committee compared women. For others, they said, look, you had no reason to do comparison at all. It's enough that these laws had this specific effect on women. Not only were they subject to prosecution and imprisonment, but it also denied them a reproductive health service that only women need. And this is reason enough to call these laws discriminatory. So this is a very well-rehearsed argument in international law, but I have some trouble with it. First, abortion is not a healthcare service that only women need. Indeed, people who do not identify as women need abortion services. And second, the argument sources sex discrimination in a unique sex-based difference between women and men and the unique medical needs that that creates. And I think this should make us very nervous because it claims to women's unique reproductive biology, and that has traditionally been one of the very basis upon which we've had discrimination against women. And indeed, today, this argument about inherent sex differences anchors a very powerful global movement in anti-gender or gender ideology. The movement seeks to affirm the natural truth of these differences, that there are these essential categories of men and women, and the worldview that entails for all of economic, social, and cultural life. And so for me, no thank you. That argument is troubling on that basis. And so I think by deciding that the abortion law was sex discriminatory because of the differences of treatment among women, the committee rejected all of that. And it made gender as an identity trait or gender as a group identity, it was simply immaterial to the analysis because these were all women. Instead, it focused on gender as a social structure. So the use of gender, sex-aligned norms or expectations to advantage some women and to disadvantage others, to advantage some women with non-viable pregnancies and to disadvantage others. Under the criminal law in Ireland at the time, being a woman mattered, but what kind of woman mattered more? In this case, women who chose to continue their non-viable pregnancies, they received the full protection of the healthcare system, benefited from continuity of care throughout their pregnancies, they received postnatal and bereavement care. And women like Mellett and Whelan who chose to abort, well, they were denied these same compassions and protections. They were abandoned by the healthcare system. They had to travel for care, carrying a dying fetus, separated from their family and friends, left to endure all of the economic and social hardship of those burdens. And this difference of treatment between the women, well, that can only be explained by gender. Namely the gendered expectations of what women should do when faced with a non-viable pregnancy. They should let nature run its course, regardless of whatever they may suffer for it. And the Irish law, well, it conscripted all women into this maternal identity and role. It set this expectation for all women. And those who challenged this norm, they challenged the self-sacrifice and subordination that it required. Those who chose to cope with the pregnancy on their own terms, they were punished for that transgression. And so in the end, gender justice, for me, it's not about comparing women to men or indeed comparison at all. It really is this struggle to remake gender from a set of essential traits, fixed categories, into a source of equality and freedom for all. You know, we all have sex characteristics, but we do not need all to have a sex. And I think gender justice is really that freedom. Thanks.
Thank you very much, Joanna. Verónica, I'm turning to you. Your recent paper on criminalization under scrutiny explains how the strategic use of public health evidence showing that criminalization of abortion does not result in lower abortion rates is changing the way how judges are confronting constitutional challenges to abortion regulations. In addition, you also explain how courts uphold liberalization when the infringement of women's rights resulting from criminalization outweighs its purported benefits. You explain in your paper that we were very much welcoming for an SRHM audience that this narrative has gained popularity in court decisions over the past decades in Europe and Latin America, and might be very helpful for legal strategies and advocacy purposes in other regions. Can you please tell us more about these jurisprudential trends, the contents of these narratives, and their possible benefits?
Sure. Well, thank you very much for inviting me to this seminar. Well, the key message of my paper is that even in countries where the protection of unborn life is a constitutional value, or the fetus is considered a holder of the right to life, even in those countries, courts can make an argument against criminalization of abortion based on public health evidence that shows that criminalization of abortion is not an effective means to protect the unborn life, and that there are alternative, more effective ways to protect unborn life that are also respectful of women's dignity and of women's rights in a way that criminalization is not. Criminalization of abortion is associated with a traditional way of thinking about abortion in law. And from this traditional perspective, there is a clash of absolutes. If society wants to protect unborn life, the only way to go is to sacrifice the rights of the pregnant woman. But this way of presenting the argument does not do justice to the complex reality of abortion. And the big problem about this argument is that it is based on a mistaken assumption that criminalization is effective in lowering abortion rates. And the evidence tells us, and we now know that that assumption is wrong, simply wrong. So the question for that we should try the court to see that the relevant question is, why would someone with a real commitment to life would choose an ineffective means of protection, particularly if that means puts women's lives and women's lives and health at risk. So what I did was that I studied decisions from courts that had authorized or required decriminalization of abortion, and I found that a different narrative was evolving. And in a nutshell, the argument is the following. First, courts acknowledge that the state can, and under some constitutional systems, the state must protect the life of the unborn. However, the courts realized as well that criminalization restricts the rights of pregnant women, and that for that reason the state must justify that such restriction are legitimate under the Constitution. And many courts that in this line of decisions that I studied that began in Europe and then the arguments were borrowed from and used in Latin America too. These courts, many of them use an analytical framework called the proportionality principle, which is used by constitutional courts to determine whether criminalization violates constitutional rights. That is not only on the abortion context, but the proportionality principle is used in many other contexts too. And under this principle, the state must successfully pass 3 tests, and each test comes with a question. You know, the first test is the suitability test, and the question there is criminalization an effective means to protect the unborn life? And this test is very important because by asking this question, we are denaturalizing the idea that criminalization is effective per se, you know. And if criminalization is not a suitable means to protect abortion rates, and we can use public health evidence to show that, then it must be declared unconstitutional because it means that the state cannot justify the affectation of women's rights that results from the use of criminal law. But even if the court thinks, and we can grant for the sake of the argument that criminalization is effective to some degree, the next question under the next test, which is called the necessity test, must the next question will be whether criminalizing women or whether criminalization is the least restrictive means available that is effective to protect the unborn life. Because if there are least restrictive means, the state must use them. And we have public health evidence, and we must use it to show that low abortion rates can be best achieved through sexual education, efficient and acceptable contraception, access to health services, preventing violence, discrimination, and stigmatization of women, and providing social support for girls and women who want to continue their pregnancies. So I always like to use an expression of the German Constitutional Court, which says that the protection of the unborn can be better achieved by working with the woman and not against the woman. And the third test and the proportionality test is called the strict proportionality test, and then the question is about the impact of criminalization on women's rights. And here the evidence is clear again. The effect of criminalization on women's lives are devastating. Between 22,000 and 33,000 women die unnecessarily each year as a consequence of unsafe abortion, and many more become sick. Sometimes they remain sick during all their lives. And women resort to illegal and unsafe abortion because forced maternity is experienced as an unbearable burden under some circumstances. So this is how intense the sacrifice imposed on criminalization for is to women. And when courts acknowledge these sacrifices, they have ruled that there are limits to what law can require for women. For example, the Colombian Constitutional Court said that women cannot be instrumentalized, that treating women as a means of procreation against their will is against their dignity. So to sum up, advocates can make an argument in court and even in parliament and can quote abortion decisions that question the legitimacy of criminalization of abortion, can use evidence produced, for example, by the World Health Organization that proves that criminalization does not lower abortion rates and that the effects of criminalization are devastating for women. But, and also lawyers need to explain these effects of criminalization on women's lives in legal terms as infringements of rights. And for that, they can be held by international human rights, because international human rights offer or provide a gender-sensitive interpretation of human rights law, and that domestic courts have can bring into the interpretation of their own constitutions. And so you can quote decisions, you can use evidence, and you can make a gender-sensitive interpretation of human rights law using international human rights standards and recommendations. So that is what I would suggest, and that's the main point of my paper.
Thank you very much, Veronica. We really appreciate for the explanation about that. And I think your paper is really fascinating to read and very enlightening on all these legal concepts. And I think it's very user-friendly for non-legal audience as well. So in terms, in the meantime, I would like to encourage the participants to pose their questions on the chat. Please don't use the question and answer tab, but the chat for your questions. So Veloshnee, you are an expert in WHO coordinating various efforts related to sexual and reproductive health and rights and universal health coverage. Can you please tell us a little bit more, on one hand, whether and how safe abortion is featured in the UHC effort on sexual and reproductive health? And secondly, whether there is space in the UHC agenda for consideration of structural factors such as laws and policies that can impact, that can have a significant impact on the availability, accessibility, and affordability of services and providing coverage for those services. You need to unmute yourself. Unmute. Veloshnee, unmute.
There we go. That's better. Thank you, Esther, and thank you, Jessica, and thank you to Veronica and Joanna. It's been interesting just listening to all of you. I mean, I'll speak now to the context of universal health coverage, in which abortion, access to safe abortion, and a range of other sexual and reproductive health services are being planned and being implemented. I think what I can say at the outset to Esther and to the participants is that we know that laws are needed to ensure equity, quality, safety of health services, and financial protection for the users. And a strong legal framework sets the rules for how the health system functions, establishes the legal mandate and access to services, and provides the means through which a government can implement UHC at a population level. However, this is where the gap is, that is a country's legal and regulatory frameworks and engaging in UHC compliant reforms are still remain weak. And this is really one of the key areas that needs further a lot of work. And that often in many countries, so to date, many countries' legal and regulatory frameworks have not been systematically assessed for their compatibility with the goals of UHC. So that's just by way of introduction, just to highlight the gap. What I'd like to cover now is to go down. I'm I'm trying to move my PowerPoint to move to the next page. Just give me a second. I'm just going to share it again. Just one sec. Okay. I think I have it. Sorry about that. So I just want to very briefly touch on the context of sexual and reproductive health and rights and UHC in the context of the SDGs. Just speak, to highlight the burden of unsafe abortions, look at some of the drivers of access to safe abortion care, look at the case of Thailand, a country which is regarded as UHC successful. And if we have time just to maybe just run through some of the recommendations and some of WHO's response. So, page down, there we go. Okay, I have it. What we know is that sexual and reproductive health and universal health coverage are both central to the SDGs and specifically to SDG 3. The SDGs, though, are silent on abortion. So the areas that are highlighted, that are important and that have been recognized are access to family planning, contraception, maternal health services. And though we do know that sexual and reproductive health encompasses a broad range of services that are preventive, promotive, curative, including gender-based violence, access to safe abortion, post-abortion care, maternal health, reproductive cancers, etc. The lack of access to safe abortion, as we know, and which Verónica also highlighted, is really one of probably the underlying drivers of the global burden of unsafe abortion. And each year, more than 25 million abortions take place across the world. These are primarily located in low-income countries, and adolescent girls, young women are disproportionately affected. Now, with post-abortion treatment, it's expensive. It requires hospitalization. It's expensive in terms of the skilled, specialized providers, healthcare providers that are required, surgical procedures, expensive drugs, and hospital stays. And the cost has been, this is important, for, particularly at a country level, to be able to estimate what is the cost for post-abortion care. In Rwanda, what they found was that it's close to almost $100 per case on average. Now, this is a upper low middle income country, which is clearly fairly unaffordable. So the annual cost of providing post-abortion care in middle income countries or low income countries is approximately $232 million per year. However, if abortions are provided safely, this cost would drop to $20 million per year, which means having access to safe abortion services. So from a public health and a resource perspective, there's a huge case to be made to Ministry of Finance and Ministry of Health, why it's important to invest in safe abortion services, as well as obviously access to contraception. So I'll just run through this very quickly because I'm sure our audience understands these barriers as well as I do, probably even better. But what we see there are three key areas that restrict access to safe abortion. First are the restrictive abortion laws and policies, and these vary from those that are more restrictive, where abortion is prohibited altogether or only permitted to save a woman's life, to those that are least restrictive, where there are no restrictions in terms of terminating a pregnancy. Now, what we do know is that even in contexts where there are fairly liberal, unrestricted laws and policies, the health system itself does play a very, very important role. And access to safe abortion can remain a challenge for many areas, for many reasons. This could be the question around availability of skilled health workers, distribution of facilities. Facilities might be concentrated in urban areas. And this is a particular challenge in potentially middle-income countries where there are less restrictions, but the health system itself is just under-resourced. And I think importantly, and quite unique to safe abortion, is the question of conscientious objection of healthcare providers. And this is a severe and important impediment. And lastly, there are the questions around administrative procedural requirements, example, waiting periods, mandatory counseling, third-party authorization, which not only challenge, but they also delay the time that when a woman can access an abortion, and then the longer the period is, it might not then become medically feasible, and which might push a woman towards an unsafe abortion or where it's under unsafe conditions. And lastly, but probably just as important as the others, is the question of societal norms and stigma. The issue of abortion stigma is well known, well documented. And as you know, both Verónica and Joanna highlighted, is the gender norms that are in place, cultural expectations around pregnancy, parenting, acceptability or rather the unacceptability of adolescents' sexuality and premarital sex, all of which come together in terms of barriers to access. What I've done here is just to probably, it's a key message that I'd like to probably leave this webinar with, is that even in countries which are regarded on the path to universal health coverage, and I'm just highlighting 3, there are many more, but Thailand being one of them, long-standing, Rwanda as a low-income country in sub-Saharan Africa has been really, really at the forefront in terms of improving access, affordability to care, and of course Brazil. But in all of these countries, restrictive abortion laws challenge access to safe abortion in combination with some of the health system's constraints. And I just wanted to highlight the case of Thailand. Thailand is one of the countries which has a long-standing commitment towards universal health coverage over 20 years. Strengthening the health system, ensuring and improving primary health care, removing the financial barriers to access financial protection. I mean, Thailand spoke of universal health coverage before it was even, I think in many ways, even recognized in many instances, and has a fairly comprehensive benefit package that covers almost all sexual and reproductive health services that are envisaged in the Program of Action and ICPD. However, abortion is permitted only by law, and it's when it's conducted by a physician, if the pregnancy threatens a woman's life or health, or is the result of a sexual crime. And abortion still remains a huge stigma in society. These are partly driven by religious beliefs and which impact also and influences the provider's behavior. And given that it remains such a huge taboo, is that most abortions, a large percentage of abortions are done what we can say are unsafe, are done underground. And this has implications for the fact that women, those facilities that can carry out abortions tend to be primarily located in the urban centers. Healthcare providers can, at their discretion, interpret the law, and that might be more, they have more autonomy, they're more able to do that in the woman's interest in the urban centers. So what you find is that in rural areas, access to safe abortion services are very, very, very much restricted. Also, given that the safe abortion is not part of the essential health benefit package, it implies a huge amount of high out-of-pocket payments, which means that women, their families have to pay for care. And this, of course, means that those who are poorer, younger, those in the informal sector often find these unaffordable and will seek care from providers who are not necessarily trained and not necessarily using the WHO or those recommended procedures. So in effect, we have huge disparities in geographic and socioeconomic access to safe abortion services. And maybe just last to also indicate that in 2014, both mifeprostone and misoprostol have long been used in Thailand, but they were approved for ending pregnancies in hospital settings in 2014. So while this is, clearly something that is welcomed and it's progress, at the same time it has limitations, is that the pills can only be prescribed by doctors at approved hospitals or clinics. So here again, there are barriers to access for what is a fairly well-recognized medical procedure. And women who terminate pregnancies on their own without having the prescription from a doctor are liable for punishment under the law. And so that's the challenge. So I think this case illustrates that UHC itself is not necessarily a panacea for improving access to safe abortion services, but there are routes in which it can be used. Some recommendations which are not new, but I think always worth reiterating, is that the health system really operates within a regulatory policy framework. And these barriers that hinder access to timely provision of safe abortion care, as well as access to post-abortion services, need to be removed. From a UHC perspective, is that we need to ensure that there's an integration of safe abortion services and post-abortion care as part of essential benefit packages and as an essential component of sexual and reproductive health within national health plans. And thirdly, I think there's need to be able to, at a country level, is to strengthen the evidence base on the social and the financial costs of access for both safe abortion and post-abortion care. As I've indicated earlier, the data shows quite clearly that post-abortion care is extremely expensive, is resource intensive. And often these costs are falling on women and their families if post-abortion care is not part of an essential package and is not financed through government and through public financing. So maybe I can stop there, and I'll just probably leave to share is some of well, my slides flipped around. I think they have, but I think I've covered some of these areas already. Okay, there we go. These are just some of the work that's been done in WHO to support this through generating evidence-based resources, technical support of countries, as well as the research. And as well as WHO has our colleagues in working on safe abortion have also recently launched together with partners an interactive online database that provides a comprehensive compilation of laws, policies around abortion globally.
Thank you so much, Veloshnee. So we have about 20 minutes left to engage with the participants and really making the connections between the legal and human rights argument that are being presented in the two papers and by Joanna and Veronica, and also with the UHC agenda. So one question to you, Joanna, that your paper importantly reflects on the connections between criminal abortion laws and the denial of public care and the socioeconomic burdens they impose as a punishment of the transgression of socially accepted or assumed norms and roles assigned to women. How do you think that this analysis can provide a useful entry point for connecting discussions on abortion laws and decriminalization of abortion to the UHC agenda?
Great, thanks, Esther. So perhaps the first thing that I'll say on this is, the C in UHC stands for coverage, not care. And that's something significant because UHC tends to be framed as a financing or an insurance issue, coverage to make sure nobody is left behind. But I think equally important are the terms in which people are included. And so as much as with law, you know, we need to stay alive to the kinds of unconscious, unnoticed ways in which gender becomes embedded in these bureau technocratic discourses of coverage. Human reproduction, for so long, it's been simply accepted as a matter of profound moral or social importance, and therefore it has warranted every kind of state intervention into the lives of people. You know, rather than seeing the gestating and birthing of a child as a profound human act, and therefore putting to it all of the care, compassion, and concern of it. So for me, what would it mean to think about gender justice in UHC? It would be to protect against any essentialist sex or gender truth, get away from binary categories of men and women as a way of structuring or achieving UHC. I'd watch for the ways in which gender is used, especially in national level debates around UHC, to rationalize away or to explain away inequalities in treatment. You know, it's quite amazing what people are willing to pay for, all kinds of forms of injustice. That's why the economic argument doesn't make sense or work for many people. They are willing to pay to harm others. And last, I would invite sort of the same kind of radical reimagining of universal health care. Imagine that we could reach every person, each to their own in their need, with nobody left behind by reason of sex or gender. Thanks, Esther.
Thank you so much, Joanna. I will come back with the second question that is very much related to exactly what you just said. But I'm turning first to Verónica. And you explain in your argument or in your analysis how the use of public health evidence can challenge criminalization of abortion laws on a basis of upholding equality and other human rights such as dignity, autonomy, privacy. How do you think these legal arguments presented by constitutional courts or Supreme Courts in turn can be useful for a public health audience to recognize that structural factors and criminalization of abortion laws matters when they are setting their UHC agenda? And again, there is a very interesting question that relates to that I would pose for a moment.
Well, I think Veloshnee explained it very, very well. Law can be a powerful tool for advancing global health. We can use law to improve the governance and the equity of health systems, to implement evidence-based intervention, to ensure the quality of services, to introduce accountability into the system. But the contrary can also be true. So bad law, such as criminalization of abortion, can do a lot of harm. And that is what we must be able to show to courts, you know. For example, criminalization of abortion entrenches stigma and discrimination and creates barriers to access to essential reproductive care. So one thing that we should make courts understand is that basic reproductive health must include a complete package. That abortion is part of basic reproductive health care, and that basic reproductive health care must include a health package of sexual reproductive services that address the need of women throughout their lifespan, especially the needs of marginalized women. And universal health coverage is it's an extremely important initiative and a promising idea because it understands that sexual and reproductive health cannot be thought in isolation from other aspects of women's lives and from other needs that women have. So for example, social protection against poverty, the eradication of discrimination and violence against women, access to education, the empowerment of women, community support are all factors that should be addressed in order to ensure that all girls and women can realize their right to the highest attainable standards of care. So what is interesting is that if courts are open to think this seriously and pay attention to the evidence, they will realize that abortion is just part of the lives of women, and that the best way, the best policy around abortion, it's a broader policy that would include universal health coverage.
Thank you very much, Veronica. Veloshnee, a question to you. I mean, there are many questions, and I'm trying to pick up some diverse, different issues that you were posing. Some of them are similar. So, Veloshnee, to you, you mentioned using the case of the cost of post-abortion to the Ministry of Health and Finance, essentially to make the economic case. Do you have any thoughts on making the case around loss of economic contribution by women, linking into recent arguments around increasing women's labor force participation rate or lack of PSC affecting women's productive work?
Oh, post-abortion care. Thank you, Lena. Thank you. I can see your question. I think it's an important one. You know, I think in much of the same way that a lot of the, and when I say economic, I mean really the healthcare costs from both a health systems perspective as well as a societal perspective has been used to make a large, much of the case for universal health coverage. And Joanna, just to maybe come back to a point you made earlier, is yes, a lot of the discussion around universal health coverage seems to be around the financing and the resourcing and the financial protection. And I think that's really part of, because of the history around financial protection. And it's located within, you know, a broader scope of social protection. But SDG 3.8 also speaks to quality, essential healthcare services and access to safe, effective, quality, and affordability. So affordability is only one aspect of it, which we ourselves can use and should use the fact that SDG 3.8, which is around UHC, speaks to more than affordability. So I think it's a useful thing to kind of keep, you know, in terms of our kind of the tools we use when we're engaging with a broader section. But to come back to Lena's question around the indirect costs of loss of income, I think that's an important one. I mean, there's very few studies, researchers actually looked at that. And I think we can go beyond, you know, one is loss of income, two is the quality of life. And, you know, there's a case to be made for looking at broader, incorporating within the economic arguments, both in terms of women's own autonomy, their own empowerment, their own income, is how does it impact on their quality of life more broadly. And I think there is, I would agree, is that there's a lot more evidence that's needed to be looking at the economic impact from a societal perspective, but also from the woman's perspective as well, to kind of complement as well what is the health system's impact, because they go hand in hand.
Thank you very much, Veloshnee. Joanna, I'm coming back to you, and I think you are getting a lot of emotional comments for your argument. So one of them, I'm picking one of them, that one of them is from Françoise, that the two cases still rely on non-viable pregnancies. How would this line of reasoning would apply in viable pregnancies, in case of viable fetuses? your argument.
Thanks so much. So it's a good point, and I kind of tried to stay true to the cases because that is what the cases were about, and that's the reasoning. But the reason that I love these cases and I wrote about them is because I think the argument extends well beyond the particular circumstances here. And I'll frame it like this and try to pick up some of the other questions that were asked. You know, for so long, the way we argued about abortion laws was indeed instrumentally about their effects, about the socioeconomic inequalities in that some women could escape the law and others couldn't. You know, in doing all of this evidence-based assessment about how the laws worked in practice and the injustice of their impacts. Here's why I like these cases. I like these cases because they attack an inherent feature of these laws. These are vile laws, in principle, inherent to the law themselves, because they are structured around this basic gender injustice, around these basic gendered norms about how people should live their lives. There's nothing instrumental in the injustice. It is inherent or principled in them. And so that's why I think we struggle with incremental strategies, because incremental strategies, they try to make these unjust laws work. The problem is they stay inside the logic of these laws. They stay inside the gender injustice of these laws while they try to soften their edges. And so for me, the radical aspect of it is to call out, I think, the injustice inherent in abortion laws. They cannot be made to work because they were never intended to work for the lives of people affected. They were never intended to protect the health and human rights of those who become pregnant and want to decide what to do with their pregnancies on their own terms. Thanks.
Thank you. Thank you very much. Veronica, a question to you. Thanks for the fascinating paper. One of the issues we struggle with is to dispel the stigma regarding abortion, using the idea that abortion should be reduced as a basis for your line of argument can inadvertently reinforce stigma. How do you address this issue?
Well, I'm in a very difficult position here because I'm looked at as defending a kind of incrementalist strategy, but I want to explain the context. Well, that is a very good question that you, the one you are doing, and Francois Girard made it before. I fully understand that there are risks and regarding this argument, but I want to explain that two things. First, that there are some legal systems and constitutions that require as a constitutional value or that the law protects the life of the unborn. And so not all constitutions do, but almost all courts under constitutional systems would say at least that the state has a legitimate interest in protecting the life of the unborn. And there are other systems, as the German system, as the Chilean system, and many others in Latin America, where the court has said that it's not only a legitimate interest, but it's required by the Constitution. So there we have a legal framework that we have to work into that legal framework unless we change the Constitution or the interpretation of the Constitution. And the second point is that I'm thinking about context of very restrictive and conservative countries, especially Catholic countries, where in the culture there is a value for unborn life, and is part of. So, for example, a strategy based on Roe versus Wade in Latin America I think it would have been much more difficult to work under that framework than to work under the European framework, where the life of the unborn is more valued as a constitutional matter, you know. So why I decided to study this line of cases, it was because I realized that for years and years and years, we were making the argument based on women's rights. But the value of women's rights in Latin America, I was desperate because they took us nowhere, you know, for years. So I said, well, I will then I read the public health literature, and it said, well, they are saying that they are using discrimination to protect the life of the unborn. And so I will make the argument that that they are not protecting the life of the unborn. So here I'm answering also Livio Zili and Lee Senderovic's question, and they ask, well, what would happen if then we have there is a new evidence that criminalization would in some way work and be effective in answering in lowering abortion rates? And I would say, first, I don't think we will have that evidence because it will probably, and maybe you can help me with this, but it will probably be bad science, you know, because abortion, it's a reproductive need of women. And this, for example, it is worth to, or it's good if people, to people to have access to abortion, but it's good also to people who have access to emergency contraception, and we would like people to have that we would like that people would not need abortion or emergency contraception because they have the common effective contraception before. We know that even if people have access to common effective contraception, there are some situations in which they would need emergency contraception, and there will be always situations where people will need abortions, and that is part of the argument we have to make. This is part of a whole package of women's need, and we have to normalize that, and we have to to take a stigma out of that. So there is a risk that saying, well, we are trying to lower abortion rates, it could work as a stigmatizing argument, but it depends on the context. I think that what the first thing we need to do is to, in conservative countries, to make courts understand how abortion is a need of women, and then they will realize that that there is not a clash of absolutes, that if we work with women, women will choose most of the time to get good contraception and not to get abortions. So I think that for legal communities and also for countries where there is a culture, a kind of maternal culture, it's easier to become into terms with this and to, at first, during the first phases of the process, to become more comfortable and then to be open to understand what the problem is. And so there is an incrementalist strategy in the sense that people become less, I don't know, anxious. And when they become less anxious, they are able to understand the problem behind it.
Thank you very much, Veronica. We ran out of time. We acknowledge all the questions that you have sent to us. We will consider, and we are hoping that in our UHC and SRHR issue that is focusing on rights matters that will come out next year, we will have a paper that is dealing with these issues, and we will make sure that we incorporate those questions that you sent to us in those papers. So we would like to encourage you to submit your papers. The submission deadline for this issue is 31st of December. We would like to emphasize that for our team issues compared to our open issues, there is no author processing charge. So there is more equitable access to writing when it comes to a team issue compared when you submit your papers to an open issue. We really would like to use this issue to enhance the debate, the intersections between human rights, legal, public health, and social and economical arguments. So please submit your papers. We will also launch a board for case studies that won't be only research oriented, but also can accommodate legal arguments, human rights argument, and other type of analysis. So please watch out for that. And we will announce our next webinar very soon on the same topic with some public health experts from countries discussing the same issue. Thank you so much for your participation. Thank you for the panelists for your time and presenting the papers and your work and your views. I wish you a nice morning, afternoon, evening, and night. And thank you very much for joining us today. Bye-bye.
Thank you. Bye.